questions, but I want to just sort of do a very sort of mapping of some of the sort of preliminary questions and the very sort of contentious question about under what legal regime we might be talking about Australia having climate obligations before moving how we might quantify any international climate reparations that Australia owes, bearing in mind, obviously, all the limitations that were discussed about at the previous panels about the, how reductive, putting that sort of monetary value on much more complex harms is. And then finally, sort of issue a warning that under the current legal frameworks, Australia is really at risk of paying compensation to fossil fuel producers under international law rather than those who are being most harmed by climate change. So just I think as we've talked about a lot already, under the Paris Agreement, countries are required to put forward successive nationally determined contributions. Australia's current one of 43-degree reduction by 2030 is widely seen as manifestly insufficient. And it doesn't really address what is Australia's main contribution to climate change, which, as Jeremy has really already outlined, is our fossil fuel exports, which are growing. A recent report by Climate Analytics showed that in 2021, Australia was the third largest fossil fuel exporter and the second largest exporter in terms of our carbon footprint. The Paris Agreement requires countries to provide financial assistance, and Australia claims that it's currently providing $3 billion or expects to deliver $3 billion towards global efforts by 2025, including $1.3 billion to support adaptation in the Pacific. And as we've heard, Australia's just given $50 million towards a loss and damage fund, despite the need being estimated at 290 to 580 billion annually by 2030. So due to sort of the limitations of the UNFCCC sort of framework, which really works in this sort of idea of trying to incentivise action by getting countries to sort of keep ratcheting out commitments over time, because of the limitations of that approach, both in terms of driving the emission reductions that we need and galvanising the climate finance that needs to happen, climate vulnerable countries, spearheaded by Vanuatu, have pushed for an advisory opinion by the International Court of Justice. The hearings were held in December last year, and we're currently waiting for an opinion. And so I just want to spend a little bit of time looking at what Australia argued in that context, because I think it's a really disingenuous argument that was being made. So while climate vulnerable states such as Vanuatu argued that while the UNFCCC Paris Agreement are, quote, part of the broader corpus of international law applicable, they also argued that they're by necessity only just part of the law governing the relevant conduct on climate change, because there's a lot of gaps in those frameworks, particularly related to mitigation, adaptation, and because they don't address fundamental questions of human rights, rights of self-determination, and many others. And thus they sort of argued that general principles of international law need to apply, particularly what's called the no harm rule and the duty of due diligence and obligations arising under human rights law. And this is really significant because if international law recognises excessive greenhouse gas emissions as an internationally wrongful act, certain consequences flow from that. The 2001 Articles on Responsibility of States for Internationally Wrongful Acts set out legal consequences for an internationally wrongful act, including the obligation to cease that act, to make full reparations for the injury caused by the internationally wrongful act for damage both material and moral, for restitution, compensation and satisfaction. And so Australia's submissions in the ICJ proceedings were really geared towards trying to argue that general principles of international law do not apply and these frameworks for reparation do not apply. And in doing so, the arguments that Australia made really aligned with those that were made by other major carbon polluters, including the United States, Saudi Arabia and China. So Australia stated that it considers the United Nations Framework Convention on Climate Change and the Paris Agreement to be the primary source of obligations under international law, and that while it recognises and shares a concern regarding the continued growth in absolute emission levels, notwithstanding these agreements, it stresses that collective climate action has led to a sizable reduction over time. And I think it's crucial to recognise here too the really problematic role that Australia has played continuously within the international climate negotiations, which I think is summed up nicely in this quote from Polly Hemmings' article where the UN rep saying, you know, Australian negotiators are all good guys until you realise that they've just completely stuffed you over. And we've seen a long history of the use of Australia lobbying in the Kyoto Protocol for an 8% increase in emissions and for what came to be called the Australia Clause being included, that effectively allowed Australia to claim emission reductions in land use and land use change that had already been done already. So the Australian submissions at the ICJ really sought to limit the applicability of general principles of international law, arguing that we should not treat climate change as if it involves an ordinary case of transboundary harm. Instead, states have agreed tailored treaty obligations that account for the complex harm, and so we can't just rely on these general principles. And although Australia recognises that the international no harm rule has informed internationally agreed standards for states' actions on climate change, they submitted that this principle of prevention does not apply to anthropogenic greenhouse gas emissions. In the alternative, Australia's argued that if the no harm rule was found to apply, then the obligation under that rule is that you do what's considered due diligence, and they say just abiding by the Paris Agreement and the UNFCCC satisfies due diligence. So they basically go back to that agreement as well by making that then the content of the no harm rule. And again, I think this is really disingenuous because if anything, the other approach should be taken that the obligation in the Paris Agreement that successive nationally determined contributions represent a country's highest possible ambition should read in the requirements of what the no harm rule under international law requires, rather than this other approach that Australia is proposing. With regard to consequences, Australia's made a number of arguments aimed at arguing that reparative approaches do not apply, particularly saying that we don't just look at the harm caused, but whether an obligation has been breached, what conduct was required of a state and what conduct the state engaged in, and sort of claiming that just because you've caused significant harm doesn't equate with the commission of an internationally wrongful act. Australia's also put forward a temporal principle that whether a state's breached an obligation can only be assessed by reference to conduct that was done at the time and whether that was an internationally wrongful act at the time. With that regard, I think it's useful to highlight that already in 1969, we have sections of, this is from Royce Kilroy's book Slick, where he highlighted that the Committee on Air Pollution in a 1969 report was already warning about the dangers of climate change. So we have that threshold knowledge at the Australian level for a very long time. And then the other arguments that are made by Australia is about causation, arguing that the best available science does not presently enable attribution of specific climate change impacts experienced by any particular state to the specific conduct of any other state, even though we know that the attribution science is becoming more and more sophisticated by the day and is already at a stage, I would argue, where we can start to make those attributive claims. So quickly now, so just sort of saying, like Australia have been making all these arguments to try and deny this sort of form of liability in international law. And so I want to think about what would a reparative obligations look like in a quantified financial sense. And because I'm not a number crunching person, I've turned to the work of other scholars and extracted some of the data that they had on Australia. But just before I want to do so, just as I said before, under international law, the obligation to make full reparations includes obligations of restitution, compensation and satisfaction. So restitution requires to re-establish a situation which existed before the wrongful act was committed, provided this is possible and does not impose a disproportionate burden compared with compensation. And while establishing a situation before excessive greenhouse gas emissions is in some regards impossible, I think there's really important scope for thinking about the role of carbon sequestration and carbon drawdown as part of a reparative obligation of restitution that Australia owes domestically and to the world. So we have, like, Indigenous ranger groups have been earning carbon credits from traditional burning in the country for over a decade now. And I think there's some problems, including these sort of programs in carbon trading schemes where the production of these credits legitimates more pollution elsewhere. But I think thinking about this sort of work, which is reducing carbon emissions whilst foregrounding Indigenous knowledge, Indigenous care for country and protecting biodiversity, could be a really important part of reparative ideas of restitution as well. And so I think we need to be thinking about these sort of programs as part of a reparative approach. And similarly, as Rachel's presentation has really highlighted, international law also imposes obligations of satisfaction. So acknowledgement about breach, expressions of regret, formal apologies, these sort of mechanisms. So turning now to the question of monetary compensation, again, as we've stressed, particularly in Jeremy's presentation, it's crucial to recognise that Australia's reparative obligations don't just arise because of our domestic emissions, which are accounted for in the UNFCCC process, but particularly due to our exports, which, as we've highlighted, is Australia's largest contribution to greenhouse gas emissions. In terms of quantifying reparative obligations, I sort of just did an exercise of drawing on some of the calculations that were prepared in this 2002 article in Nature Sustainability by Andrew Fleming and Jason Hickel. So in that article, they sought to contribute to the broader debates on climate reparations by offering an empirical method of quantifying compensation owed for the appropriation of atmospheric commons. So they tried to quantify the amount owed by countries that have or will have exceeded their fair share of the carbon budget. That gives us a 66% chance of limiting warming to 1.5 degrees. And they found that even in an ambitious net zero scenario, the global north collectively overshot its fair share of the 1.5 carbon budget by a factor of 3, and that compensation of 192 trillion would be owed by overshooting countries to the global south by 2050. So here they had a spreadsheet of all the figures that sort of accompanied their analysis, and there I just tried to extract the data that they made for Australia. So I'm a little bit nervous that I made mistakes sort of comparing. We're going from kilotons to gigatons and stuff, but I hope this is accurate. So their first step was to estimate the levels of atmospheric appropriation, and they looked at cumulative emissions of 169 countries with respect to equity-based shares of the 350 parts per million, 1.5 degree and 2 degree carbon budgets. So here we have sort of the global carbon budget. The second then column shows what Australia's fair share of that carbon budget is. The fair share is obviously a really complex idea, and there's a wide range of literature on how we work out what fair shares is. In their model, they just sort of do a per capita approach. So their idea of fair share is just based on proportion of the global population. And then you can see when that carbon budget was exceeded or is predicted to be exceeded, and when Australia would have exceeded its fair share of that budget. So here you can see on this slide that in 2019, Australia had cumulative emissions that were 2.8 times 7 higher than its 1.5 degree.
One clarifying question, Julia. Do you know if it was cumulative per capita or simply a snapshot of population right now?
This is cumulative per capita.
So it's like population cumulative as well as emissions cumulative?
I think so. And they also worked on, that's the other thing I want to clarify by digging more into the numbers, a consumption-based approach. So they tried to take into account imports and exports, but I want to double check the numbers to make sure they have properly factored in our fossil fuel exports as part of those calculations. And so here, these are some of their general calculations. And again, you can see we've vastly exceeded. And then they put costs based on the IPC, marginal abatement costs of carbon on there. And then these are the figures, if I haven't done it wrong, that they come up for Australia, assuming that we transition to net zero by 2050 in an equitable way. They would argue that Australia owes 4,020 billion in the medium scenario. So again, I think quite unrealistic that this is ever going to be paid in those sort of sums, but I thought it's an interesting exercise to put on the table. And just knowing that I need to finish quickly, just quickly also want to flag the danger posed by investor-state dispute resolution at the moment, particularly because we have everyone's favourite climate villain, Clive Palmer's Sephora Investments, Singapore-based company Sephora Investments that incorporated, is now taking the Australian government to court in 3 different actions. One under this ASEAN, Australian, New Zealand Free Trade Agreement, where he's seeking $43 billion in damages. That's relating to the mineral exploration permits by Warrington Coal in Queensland's Galilee Basin. The second, for $69 billion under the Singapore-Australian Free Trade Agreement, is focused on what I think was a really landmark historic agreement in the Queensland Land Court, where the court recommended that the coal mine should not go ahead. And he's arguing that breach minimum standards of treatment required under the Fair and Equitable Treatment Clause. And the most recent of these cases for $10 billion relates to decisions of the Queensland government to refuse Environment Authority and development approvals again for a coal-fired power plant, again as part of the Waratah Coal Galilee Coal Project. So there's a really dangerous asymmetry in the available legal mechanisms that are available, where fossil fuel companies are entitled to protection under legally binding investment treaties, but climate-affected communities must rely on quite politically contingent and legally fragile avenues for redress. And I think there's therefore a real structural bias in the international legal order that prioritises corporate compensation over climate justice, protecting fossil fuels companies' expected profits, while creating legal and procedural barriers for climate victims seeking reparations. And I think our challenge is to work out how we can foreground the need for reparations as a crucial component of climate justice and envision the pathways towards that objective. Thanks.